nature doesn't operate with any concept of justice. When a younger, stronger lion forces the older pride leader away and then proceeds to kill the cubs of that former leader, this isn't filiicide. This isn't murder in the same way as when a gang of chimpanzees beat one of their members to death. They're not doing it because of a sense of murder. They're both operating out of instinct. So it's only mankind which has a concept of justice, which is just one of many abstract theoretical concepts that we have thought up. And as an abstract construct, we try and give it shape and definition by enshrining a code of laws to underpin it. So that could be from Hammurabi's codes through to the Old Testament, Plato's Republic, all the way to Thomas Hobbes' Leviathan, that we have this system of justice putatively under some moral notion, but actually it's to stop us behaving like the gang of chimpanzees and the younger thrusting lion. As Hobbes says, life is nasty, brutish and short, and it's basically to keep us as human beings together in a society without falling upon each other in sort of murder and other terrible crimes. So these laws, at least in the Western democracies, are sort of transacted by the court system. And the court system has some very, in theory, strong rights. The right to a defence, the right to a trial of your peers, the right to not incriminate yourself, the right to have full disclosure of evidence. But it's a curious mechanism whereby you've got this abstract concept of justice, which is transliterated into a codified set of laws, but then is enacted through the legal system, through the courts. These three things are all operating on different levels. You've got pure theoretical concept, you've got a code of laws which are prescribing human behaviour, and then you've got the way that the court system works with laws of evidence and things like that, which are based in materiality. Obviously, the sort of the easiest way of securing a conviction is for the accused to plead guilty. Even if they've given a confession while under interview with the police, they can later renounce that and say it was under duress or they weren't in their right mind. So, assuming that you don't get a guilty plea or a confession that can't be thrown out, you're then thrown back onto the notion of evidence. And as I say, that is based in materiality, be it what someone saw or heard as an eyewitness or an ear witness, to forensic material, through to trace material such as DNA and sort of other biological evidence, which is even more sort of evanescent than, say, a shard of a bullet casing or whatever. So one of the things that my book considers is this sort of unequal languages between an abstract concept of justice, the laws enshrining and underpinning and defining that justice by prescribing behaviour, and the way of prosecuting that justice in cases where it's been alleged that justice has been broken through criminal behaviour, which is largely based on material evidence. So you've gone from the purely abstract to the base material, and how do those things talk together? Are they actually answering the same thing that each is asking as questions?